kind of
Your Honor,
moving toward,
may we approach?
sure.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan.
To include, this will be the last continuance. We'll continue this full cycle till 10/14, 10/16.
I thought it was the 16th.
What's that?
This is Mr. Lee. I didn't announce it.
Sorry, probably should have waited till you came up before we announced it. Apparently, we're still working on a few things and communicating back and forth. It looks like this will be the last continuance, so kind of trying to work toward a resolution. If not, we'll have a trial in the second.
Yes, sir.
Okay. Thank you.
Is the rest of your inmates, Mr. Smith? You want to
I do have I have a couple of inmates.
No, I've got them ready for you. Do you want to do them?
Yeah, we'll do all of yours and then you're out of custody as well.
This is Mr. Cobb.
The judge, I talked to the state, we're arguing over 3.5 months. Having said that, is there a date this week that we can bring him back?
Well, we have jury review.
What day is that?
That's Thursday. Excuse me, no, Wednesday morning.
Judge, I can do it. I gotta be here for Judge Schlechter at 9 o'clock, so I can do it.
Your Honor, just respectfully, I had on my calendar that jury review was Thursday. Did it change to Wednesday, Your Honor? Okay, thank you.
Am I right?
I thought that was for October.
No, it's Thursday.
Mr. Jones, I'm sorry, what day do we really on this?
So
It was specifically changed. That's Wednesday.
It is changed to dates, Your Honor.
Thank you. So jury review at 9 a.m. without subpoenas.
Yes, sir.
Do you look like you're going to be able to have a resolution at that time, or?
Judge, I think we'll ultimately get it resolved.
This is Mario Lee.
State just needs to drink tea or something, and we're real calm and come back on this. Mr. Lee, so Judge, Mr. Lee's case, the state had emailed me, and I basically met with Mr. Lee yesterday.
And this is 23 CF 148. Sorry, go ahead.
So at this point, Judge, I'm going to say that I need a continuance, and I don't believe the state has any, state doesn't have any objection.
No, Your Honor.
So, my only question is, we're a year and a half into it, just kind of where are we at as far as,
Judge, I think the state there was some additional discovery. I gave them a terabyte flash drive, and I've never gotten that back. They were going to download everything, but I think things have changed based on what's happened with co-defendants. I think there's some movement, but then there's another charge that popped up based upon a DNA test, and so it's all new to me about the DNA that's on.
So there might be another charge?
Well, I think they're going to
Well,
amend it.
Your Honor, at this point, he has another case, but yes, there was a DLE report that implicated him in a gun charge, Your Honor, so that he had possession of a gun, so.
So
She may be amending the charges. In my case, I guess is what I'm hearing.
okay. Yeah, I'm just kind of a general, hey, we're a year and a half into it, where are we at, kind of, that's the inquiry, so this is one of those cases that taking different twists and turns. So we'll continue this till 10/16.
Okay, thank you, Judge.
And hopefully, maybe I would ask that by the next cycle, we kind of get a better feel for where
Yeah,
things
sure.
are. where
He has
we're
a,
at.
he has a 24 case that came up from rescue, and I think Mr. No Judge recently got the, there's a global offer that's on the table.
Okay. Meyer Holtz, 24 CF 650.
I've got it ready to plead. I may approach your honor.
You may.
Judge, Mr. Meyerholtz, 24 CF 653. Judge, he's charged with possession of controlled substance. He's going to enter a plea to that and receive, basically, he'll be adjudicated guilty, and he'll be basically given credit for time served. He'll have $615 in court costs, $150 court-appointed legal assistance fee. We're asking for 6 months to pay those.
So there'll be an adjudication on the possession of a controlled substance.
Yes, sir.
Okay. State,
Yes, Your Honor, that's the state's agreement.
Mr. Meyer Holtz, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
Yes,
So, you heard your attorney state the terms of the plea agreement. Those same terms are contained in the written plea agreement that you signed. Just want to make sure you read this closely, gone over it in detail with your attorney. Had all your legal questions answered. Importantly, you're waiving some valuable legal rights, constitutional rights, right, that force them to prove their case, blah. Have you had all that kind of explained to you? You understand that?
Yes.
Okay. You believe that this is in your best interest to enter into this plea and get a final resolution of this today?
Yes, sir.
And you're entering this freely and voluntarily.
Yes, sir.
Based upon that testimony, the court will accept your plea. The defendant is entering a no contest plea, will be adjudicated guilty on the underlying count 1 charge of possession of a controlled substance. The sentence will be credit for time served, so you'll be able to get out immediately. $615 in court costs plus $150 legal assistance fee. You'll have 6 months to pay from today's date, and then it'll go to collections. Okay? Thank you very much.
Judge, this is approaching the lectern is Roselle Tyrone Lee Payton, 23 CF 2054, if I may approach.
You may. Thank you. Would you announce the terms?
Yes, sir. So, Judge, Mr. Payton is going to enter a no contest plea to the lesser included offense of sale, manufacture, or deliver a controlled substance. The understanding with the state is that he would be adjudicated guilty, and he'd be sentenced to credit for time served, $615 court costs, $150 court-appointed legal assistance fee. He'd ask for 180 days to pay the dollars and cents.
Your Honor, that's the state's agreement.
Very good. Mr. Payton, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement. Put your hand down. And those same terms are contained in the written plea agreement. I'll look here, make sure you signed it. Which you signed. So I just want to make sure you read this closely and gone over it in detail with your attorney.
Yes.
Had all your legal questions answered about the plea, how it affects you. You understand that by entering this plea, you're waiving the right to go to a trial, waiving some private rights that you have even in the U.S. Constitution. Do you understand that?
Yes, sir.
You believe it's in your best interest to enter into this plea here today? And you're entering this freely and voluntarily. Nobody coerced you, twisted your arm to get you to enter into this, did they?
No.
Okay. Based upon that, the court will accept your plea. You're entering a no contest plea. And you're entering a plea to a lesser included offense of sale, manufacture, and delivery of a controlled substance, and they've got the statutory citing here. You will be adjudicated guilty of this charge, and you're sentenced to credit for time served, so you basically be able to get out immediately. You're not going to have to serve probation or anything. You are required to pay court costs that are payable within 180 days, and $150 court-appointed legal assistance fee. Any question concerning any of this?
No, sir.
Okay. Good luck.
Those are the only four we got to do one for. Those are the only four that we have to do one
We've
for.
got some out of custody cases for you.
Just, let me cover those. Christopher Ballou, the city made an offer, over the weekend, and I spoke to Mr. Ballou. I think it'd be best if we just put this on the next out of custody pretrial conference. If you remember, Mr. Ballou had a pending case over in Escambia County. He was not able to resolve that, but he is out on bond. So, he's always stayed in touch with me, so I just asked if we put on the next out of custody pretrial date.
Very good. We'll continue this until 10/14 at 9 a.m.
I then have Alicia Dean. We'll leave it to Wednesday.
Yeah, I mean, we're in that section.
So Judge, we've agreed to put this on for, Wednesday jury review. And there's two witnesses that we listed as reciprocal discovery witnesses that the state would like to speak to. And so we're gonna leave this there for Wednesday, and she and I are gonna talk about how we're gonna get those people talked to. So it probably is gonna be set with subpoenas, I'm assuming?
My subpoenas are out.
Okay.
Okay. So are we looking at a plea or trial? Is that kind of?
Yes,
That's
sir.
correct.
So that's a jury review this Wednesday at 9 a.m.
Judge, when is the jury trial?
Well, it probably will be not the next week, but the following week.
So.
The next 2 weeks, but there are some issues of coverage with one of Brown's hearing, but it looks like it will not be next week, but the following week.
So more like.
We'll look at that. That's kind of one of the things we look at in the jury review.
And
What I'm saying, I don't know exactly.
Okay. I just know that I'm planning on being out of town on the 26th, 27th, and 28th. of
Your
August.
Honor, we'll speak about this on Wednesday, but I believe the state could do both weeks. The state's witnesses could do both weeks, so we'll speak about that. I think the second week is doable.
Okay.
Good. Exactly what we said. Judge, I then have Keith Golden, I could approach.
Did you announce the terms of the agreement?
will, Your Honor. On Mr. Golden's case, Judge, he's got two case numbers, 21 CF 2522, that's a violation of probation. And then he's got a new case number, 23 CF 2495. The agreement with the state is that if he will admit to the violation of probation in the first case number, that the state will dismiss the new law violation. The agreement with the state as it pertains to the violation of probation is that his supervision would be modified to have it to where from today for 6 months he's on community control, and then it'll fall back into probation because he was placed on 5 years probation in the early parts of 2023.
So they're not extending the probation, you're just adding the requirement for the next 6 months of the community.
Right. And Judge, I will tell you that I talked to his father because he's got some special issues that he deals with in his family, deals with. But his mom and dad own a restaurant and he goes to work every day with them at the restaurant. I just want to make sure that's not going to get crossed up with community control, but they're basically with him. He's with them 24/7.
Right.
Either at home or at work.
Well, I can't, I don't control probation, but you always have the right, not always, you have, that's one of the exceptions of getting out of the house is when you're going to work.
Well,
So if you're going to work, you got, anyway.
if there's an issue, we'll come back to the board. I don't foresee there to be an issue. There'd be $100 $100 court cost.
Right.
And he'd have to complete the original requirements of probation.
That's
I was
right.
privately retained.
Very good.
Your Honor, that is the state's agreement, and the original requirements did include the GPS module, so that remains in place.
It does
It
include.
does, yes, it did originally include it, and does remain in place.
Okay. Very good. Mr. Golden, would you raise your right hand, sir? Do you swear or affirm? Would you raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
Yes.
Okay. So you heard your attorney state the terms of the plea agreement, and I see those same terms are contained in the written plea agreement that you signed. So I just want to make sure, have you gone over the written plea agreement with your attorney and make sure had all your legal questions answered about your plea agreement, about this plea agreement? Okay. You believe that, you understand you're waiving the right to go to a trial. This will be a final resolution of this case. You believe that's in your best interest? And you have had all your legal questions answered by your attorney?
Yes, sir.
And you're entering this freely and voluntarily? Yes? Yes, okay. Just want to make sure you understand what you're doing, and you're, we twisted your arm to get you to enter into this. Okay. Good. So based upon that testimony, the court will accept your plea. And the state's in agreement on that?
State is in agreement, Your Honor. We also announced the null pros in 23-2495.
And with that announcement of the dismissal, the null pros by the state of that 2495, the court will accept the plea here, the defendant admitting the violation of probation in 21 CF 2522. There'll be an adjudication of guilt, and his supervision on that case will be modified, that the next 6 months the defendant will be on community control. It doesn't mean you're extending your probation, but the next 6 months will be on community, and there's more requirements. You understand that in community control? They also call it house arrest. That's how different it's like being on house arrest. And then you'll have the special conditions, $100 court costs, and you must complete all your original requirements of probation. Okay? Okay, any questions? Okay, good luck.
Thank you, Judge. Judge, I've been at Karen Hyler.
You got Eddie Hudson?
Judge, I saw Hudson on the docket, but he wasn't brought from the jail.
He's not in? That's why.
How did he get out of jail?
I don't know.
He was in the jail when I saw him yesterday.
Can we check that again? Check that deal, make sure.
Because he was out on bond on this case, and then he got a new case. and got put in jail, and they revoked his bond, is what I was told. I saw him yesterday.
I believe you.
I chatted with him yesterday.
We'll check.
Okay, so Ms. Hyler, Judge, I gave Ms. Hyler about 8 videos on flash drive last week. She's watched, I think about half of them, and she's scheduled an appointment to come meet with me to have further discussion about the state's offer, but it's not ready to be resolved just yet, Judge. I need to continue it one more time.